Everybody. Marye Dean Esquire here at the WallStreetLawyer.com, coming to you live on Fly Nubian Queen, where Black women have a voice, and I'm one of those proud Black women. Also live streaming today on BlackWallStreet.com, because Black wealth is critical to Black power. And I am not alone today. I brought a beautiful lawyer that I know from way back in the day. Well, I know her husband from way back in the day, but I actually just met her Sunday as we were two lawyers on the same panel for the brunch. And I just could not wait to get her on this stage and talk about what she does and how well she does it. Why? Because the turkey leg hut just filed for bankruptcy, and she is an excellent bankruptcy attorney. So whether injured or suffering from financial distress, Culpepper Law Group helps individuals and businesses get the fresh start they deserve. She practices personal injury law as well as bankruptcy law. So welcome to the stage.
Thank you. Thank you so much, Marye. Thank you so much.
Okay, so let's get into this. I want to show you guys. Make sure you hit the share and subscribe button and drop your B1 in the chat. Let me know that you are here with us. Let's see, we got some commentary. So we're talking about the turkey leg hut. They want to talk about Trump. Breaking news: Trump is being sued by Truth Social co-founders because Trump manipulated the stock to reduce the stake by over 50 million. This securities lawsuit can derail the deal. Once a corrupt come in, always a corrupt come in. Okay, we're talking about the turkey leg hut today. Okay. So drop your B1 because we do put Black people first. And I want to, let's say, get into this. I want to get it. I'm going to play a little clip. Give me a second to add this to the stage.
At 4:30, the owner of a popular Houston restaurant, the Turkey Leg Hut, has filed for bankruptcy. According to new court records, Nakia Price has filed for Chapter 11 bankruptcy. The documents show Price is nearly $5 million in debt to 19 creditors. This includes more than $400,000 to the SBA and nearly $2 million to the Texas comptroller. All of this comes after a fire damaged part of the restaurant's business earlier this month.
All right. So I brought the bankruptcy attorney in here because I have some questions for her. And only a bankruptcy attorney will give me these experts. So first question I have for you is, what exactly is the Chapter 11 bankruptcy?
Okay, so a Chapter 11 bankruptcy is a business bankruptcy where many businesses file to reorganize their debts. In the present case, I was able to look at the bankruptcy filing, and it appears it was triggered because there was a lawsuit going on with the ex-partners where the judge ruled in their favor and was ordering the Turkey Leg Hut to pay up. So versus paying up, they took the alternative and decided to do a restructure by filing a Chapter 11 bankruptcy. And I must state that they filed a subchapter 5, Chapter 11, and this is a bankruptcy geared toward small businesses because it's cheaper, it's more streamlined, and it should help them to go ahead and get their debts reorganized and realigned.
So wait a minute, you just gave me some tea. So how far after the judgment was ordered that they decided to file for bankruptcy?
Pretty much immediately.
Oh,
pretty much immediately, because now I would definitely want to give a disclaimer that I'm not affiliated with this lawsuit at all, nor do I know anyone associated with the Turkey Leg Hut. But I would say that most likely their bankruptcy attorney went ahead and filed that before any liens or garnishments or any type of business assets could be liened off or sold off for the amount of the judgment.
Okay. So they filed for the bankruptcy before the other party was able to perfect that judgment.
There you go. Most definitely. And in addition to that, they filed the petition. Now, what this does, upon filing the petition, it triggers what's called an automatic stay, right? So the automatic stay will keep any creditors, any lawsuits, any litigation, anybody that's threatening to sue. Basically, it's paused. Everything that they're trying to do to get their judgment or to get money from the turkey leg hut, any of those type of collection efforts are paused. They have about 120 days before they file the rest of their schedules and petitions. So that's going to give them the some relief, because in that 4 months, and most likely it will go further than that, nobody's going to get paid. So all creditors just have to sit there and stop and just wait.
Okay, got it. And how common is it for businesses to file for bankruptcy?
It's pretty common. Now, especially when you have businesses such as this, when they have litigation going on and creditors threatening to sue. I looked in the petition, and in addition to creditors being on the petition, some of those creditors are priority creditors, such as IRS, things like that. Now, those creditors will have to basically take a liberal plan amount that Turkey Leg Hut is able to pay. So, and also it's going to stop the interest and penalties that usually continue going when the IRS is owed money.
Okay, so you say they're going to have to take a liberal payment amount. Does that mean that they have to take less money, or are they taking less payments on the money owed?
Okay, so as far as the reorganization, there are a lot of different things that can happen. A lot of these creditors, the interest rates may be dropped. The actual amount of the debt may be lessened, so they could take a less amount. If they're able to make payments, then those payment amounts most likely will be reduced so that it can be realigned so that they're able to make payments. And basically the unsecured creditors, the credit cards, things like that, they're probably going to get pennies on the dollar. So they're not going to get everything that they are stating that's owed to them.
Now, for everybody out there in internet land, on these internet and YouTube streets, what is an unsecured creditor?
An unsecured creditor is any creditor that is not able to file a lien against your business assets. So basically a loan that is not secured by your business assets. So credit cards, things such as that, those are considered unsecured creditors.
And correct me if I'm wrong, but a mortgage on real estate would be considered a secured creditor.
It would, most definitely. That would be a secured creditor. Now, in looking at Turkey Leg Hut's schedules, I did notice that as far as assets, they value their assets between 0 to 50,000. However, as far as liabilities, we have 1 to 10 million.
So if they don't, how can their assets be so small, especially when the business office is a house that sits right behind the Turkey Leg Hut that I'm assuming that they own? Maybe they don't own that house. They're only renting? Question mark.
I'm assuming so. I'm assuming it's only rented. Now, they have filed a list of schedules telling the court who their creditors are. However, these creditors are going to have a chance to come in and object and file claims as to what their amount, how much they're owed. And some of these creditors may, because I noticed there was a dispute with the creditor that they had the suit in, the ex-partner. They filed that as a creditor in their schedules. However, they put the amount as disputed. So I think there's some more coming with that. In addition, leases, credit cards, executory contracts, these are able to be rejected at this time, and the debt that they own on those will be wiped away. However, I'm sure that the landlord will require them to get out of the property if they intend to reject the lease.
Okay.
So some more is coming here. In addition, I noticed that the owner of the Turkey Leg Hut, she is also a creditor. She is stating that she's owed over $700,000.
Okay. So this would mean money that she loaned from her personal account put into her business. She's now claiming herself as a creditor that I I'm also a listed creditor. Now, question: how will the bankruptcy court treat her as a creditor as opposed to the other creditors?
It depends. It just depends. So it's going to depend on whether there was an agreement between her and the actual LLC, the Turkey Leg Hut LLC.
Pause. Which reminds me that, guys, having your paperwork together, it never comes up until it comes up, until you're being sued, until you're trying to get a lease or a mortgage. Now your paperwork comes up. And so you can put money into your business, but in order to prove it now that she wants to include herself as a creditor with bankruptcy court, what does she have to have, Attorney Lashundra?
She has to have that agreement, that contract.
Between her and her business.
That's
A loan
correct.
agreement saying that I loaned my business this money on this
Right.
particular date. Mhm.
Right. And I don't know. This bankruptcy was just filed, and there are deadlines coming up. However, I'm sure we're going to see a lot more proof of claims from other people who may be creditors of the Turkey Leg Hut. In addition, I know that there was a spouse that was just ousted, as to what I'm hearing, the rumors, the rumblings, and they may also have a claim against the Turkey Leg Hut. We'll just have to wait and see.
Yes, Lennon said as much on his own Instagram.
Oh,
And
really?
yes, he has. And honey, now he is slanging oysters right across the street.
Oh, I heard about that. Now, I love me some oysters, okay? On a side note.
We're gonna have to go get some because
Most definitely, most definitely.
he is slanging char-grilled oysters across the street.
Now, I would also expect, because of course we talked about the automatic stay that's triggered from the petition.
Mhm.
However, creditors are able to go into court and ask the judge to lift the automatic stay. I'm expecting some of those filings to be coming here pretty soon.
Excuse me. And on what grounds would the court lift an automatic stay?
They would lift an automatic stay. So, for instance, if any of the there are several reasons. So, for instance, if any of the contracts were induced by any type of um, fraud or any types of intentional actions that were done, the court could state that maybe the contract or the obligation was induced in bad faith, and therefore they do not get the protection of the automatic stay. So those are some things that may happen or may come up that would allow a judge to go ahead and lift the automatic stay. It's very rare that you see a judge do that, but there are instances that it does happen.
Okay. That's very interesting. Very interesting. So yeah, she did. She terminated. I believe her husband got fired along with some employees. They all got fired by email, I believe. These emails were circulating online. And the business office. What rings sketchy in my mind is the business office catching on fire, as they showed in the clip towards the end. Does that scream evidence of fraud to you, or is it just something that just could have just happened?
I'm not sure, so I'm not going to really, it definitely is a very, very, it's a coincidence that, statistically speaking, I mean, hey, that's something that rarely happens. So I will just say that it does seem to be a very, convenient coincidence. Let's just put it like that. However, I will state that in a bankruptcy proceeding, Chapter 11, if, let's say, there are any proceeds from any type of insurance or anything like that, that does not go to the Turkey Leg Hut or their owners. That goes straight into the bankruptcy estate, and the trustee will control that.
Oh, okay. Okay. So, but they would have, I'm not sure how long ago the fire happened, but I wonder if that check probably will still probably be processing. Yeah.
So the bankruptcy court will definitely get ahead of that check and get that check.
Okay. And then what would the bankruptcy court decide? Whatever they decide to do with the check?
Oh, they'll take the check and they will distribute it to the creditors.
Even though the check is technically to make them whole after the fire. It's supposed to go to replace the home or rebuild the office back up.
that they will allow that will happen. But if there's anything after that, if
Okay.
there's any money left over after they have, done the repaired the office, then those proceeds will go to the creditors and they'll be distributed through the bankruptcy trustee.
Got it. And I make sure you guys, this is Marye Dean Esquire here, and we're coming live with attorney Lashundra Davis Culpepper Esquire with the Culpepper Law Group. She is the bankruptcy attorney and personal injury attorney as well. And we are talking about the Turkey Leg Hut, who has recently filed for bankruptcy. This hit the news waves on yesterday. We do have a question here coming in from Gloria Washington. Good morning. Is it difficult for an individual to file for bankruptcy without an attorney? Okay, so that's a question. And guys, if you have questions about bankruptcy, feel free to drop them in the chat and I'll give them to our bankruptcy attorney expert here.
To answer your question, Gloria, no, it is not difficult for an individual to file for bankruptcy without an attorney. However, there are some things that you want to make certain of. You want to make certain that you exempt property, because if you do not exempt property, it can be taken by the trustee. I once saw a young lady who filed for bankruptcy on her own, which many people do, and you can do that. And she went into court and she had two homes. She had a house that she stayed in, and she also had some rental property. And she did not realize the rental property could not be exempted because she did not exempt it on her paperwork. And so therefore she had an issue, and the trustee actually ordered to sell the rental property. I think if she probably would have thought that through a little bit better and known more of the statute behind the bankruptcy code, that she could have planned that out a little better so that she could have kept not only her homestead, but made alternative arrangements for the rental property.
Wow. And so that's why it is important that we hire attorneys. Like, you don't need an attorney to do anything for you. You don't need an attorney to go to court. You don't need an attorney to draft your contract. You can do all of these things yourself. But the reason why you hire an attorney is because they are the experts, because we went to school for 7 years and then been doing this almost 20 years. So we've read these contracts, we've read these codes, we've read these statutes. We've done the work. We're familiar with it. We've seen these laws and these statutes and the way they work within the court system and within clients and different fact patterns. And so when we'll know how to handle it so that you don't end up in the situation like that young lady. Okay, she said, thank you. Do you have any more questions for Miss Lashundra Culpepper? Why don't you tell them where they can follow you online?
Sure. You can follow me online at Culpepper Law Group under Instagram and Facebook. In addition, we're on TikTok as well, LinkedIn, all the favorite social media sites that we all love to visit.
And I also dropped her schedule link in the chat. So if you want to book a consultation with attorney Culpepper, please feel free to do so. Okay. And what other advice? What advice do you have for a small business owner who is struggling to pay their bills and think that bankruptcy might be an alternative for them, but they are afraid to put that dark cloud over their head?
I tell them, do not be ashamed. I know that in the past, people I've heard different myths about bankruptcy. People have called, if I file bankruptcy, I lose my home. Will I lose my car? Am I going to lose everything? No, it does not work like that. If you're struggling in financial, as far as drowning in debt, then you want to get relief from it. And bankruptcy is a great way to do it. And not only will we help you with filing for bankruptcy, we'll also help you in rebuilding your credit as well. So it's nothing to be ashamed of. Actually, in a Chapter 11 bankruptcy, such as this one that the Turkey Leg Hut filed, you'll notice that if you're able to look at the schedules, you'll notice that nowhere on anything is her social security number. This bankruptcy is not going to affect her credit or her social security trade lines or anything like that, because it definitely will not be on there. It's only affecting the business entity. So if you're thinking about filing and you're not quite sure as to which direction to go, give us a call. We'll be happy to sit down and help you and come up with a customized strategy.
Okay, and that's important to note. So this is a corporate bankruptcy. This is a bankruptcy filed by the Turkey Leg Hut, but not Nakia Holmes personally. So her personal credit is not going to be affected at all because she has a real business that she set up that has that box around a protection around it to protect it from her personal assets. So,
and I do expect for this to be a very litigious bankruptcy case.
And why do you expect that?
Because of the creditors that are involved, because of the previous lawsuit. Like I stated, she put in her schedules that she put the amount, but she put the amount was disputed. So I'm assuming that the plaintiffs in that case will come over to bankruptcy court and will try and get that ironed out as far as what is being disputed as far as the amount. So that most likely will be argued in bankruptcy court. I'm assuming that whomever she's her landlords, if they are due monies at this time, I'm assuming they'll go ahead and file that motion to lift stay. Any other creditors that would like to go forward with litigation or any type of lawsuits. So that's why I'm expecting to see a lot more with this. And in addition to her husband coming in as well, her ex-husband, or I think they're going through a divorce. I'm not quite sure where that's at. Yeah.
Okay, so we'll have to get you in here when some more things transpired during this interesting bankruptcy case.
I would love it.
Coming from AR, how does it affect starting another business?
It does not. It does not at all. She's free to set up another business right now if she wants to, and the bankruptcy would have no effect on that. It only affects the entity that files.
So that would be the Turkey Leg Hut and the Turkey Leg Hut only.
That's it. If they wanted to start a char-grilled oyster hut, a char-grilled oyster hut, they could do that.
So there's this doctrine, right, in law called piercing the corporate veil. Mm-hmm. And so if the court is that law used in bankruptcy as well? Does that happen? Have you seen that happen where a corporation maybe who is not running the corporation like a true corporation, an LLC that is not abiding by the laws for a limited liability company, they're a corporation that is not having the meetings, doing the bylaws, commingling assets. Are they able to, could they pierce the corporate veil if any of that is found out to try to go after her personally?
It's possible if they've been mismanaging, which of course, I think that's more of your lane, right? Attorney Marye Dean, Esquire.
Yes.
You deal with companies every day, and those are some of the things that I know that you help companies to get straight as far as their books, as far as the financials and things like that, so that they can make sure that they're not doing those things to get the corporate veil pierced. It could happen. We'll just have to watch and see if anybody brings that up.
That's interesting. Especially interesting now when you think back to that fire.
I know. And is this the first or second fire?
Well, that's the thing. There was a fire. So the business partner that won in the lawsuit that they owe the money to,
right?
I believe he owns 5015 across the street, right?
Mm-hmm.
That building burned down and has been refurbished, rebuilt back up and to what it has now. But you know, the rumor has it, the person that, when you look at the video of the men who are on camera, that body type looks very familiar. That's all I'm gonna say.
Oh wow. We got a problem on Alameda Street, huh?
Yes, Alameda hot, honey, hotter than little.
Very hot. The block is hot, right?
The block is hot. For those of you who are just tuning in, it's Marye Dean Esquire here at the WallStreetLawyer.com, coming live with attorney Lashundra Culpepper, a bankruptcy attorney, our bankruptcy specialist, speaking on the Turkey Leg Hut, who filed for bankruptcy on yesterday. I believe they're owing maybe $5 million in debt. That's a lot of debt.
It is a lot of debt, especially for the amount of assets that they have. That's very interesting. Also on the schedules, and what a lot of people don't realize as well, is that if you file a Chapter 11 bankruptcy, you can also put some of your personal debts inside of that bankruptcy. And I did notice there was an American Express debt for like $55,000. So I'm not sure if that's a personal debt of Miss Nikita's or if that's the Turkey Leg Hut's debt. But either way, you can put that within your Chapter 11 as long as it's under 50% of the total amount of debts.
Wow, that doesn't seem that sounds like commingling to me.
It's a 2-for-1. It's a 2-for-1.
Yeah. Okay. Okay. And they just allow that. You can
Yes.
put in your personal debt with your. So it's the kind of bankruptcy they filed. Is that only for small businesses, or is
Yes.
that just okay?
It is. It's also businesses with debt under $7 million.
Okay, so they're at 5.
Mm-hmm.
So how many different types of bankruptcies can you file?
Okay, so for individuals, we have Chapter 7 and Chapter 13. For businesses, we have Chapter 11. There are also Chapter 12 for farmers, agriculture type of businesses. But just for the normal individual, Chapter 7 or 11. And for businesses, we can do a Chapter 11. However, if you want to just liquidate, you want to liquidate all the assets to pay off the debtors, you can file a business Chapter 7. But as in the case here, she does not have enough assets, or the Turkey Leg Hut does not have enough assets to liquidate, because they only owe, according to their schedules, they only own about $50,000 at most worth of assets.
So that's the assets and cash flow are two different things, because you can't get in $5 million of debt if you're not generating, millions and millions of dollars. It just doesn't happen. So, but they don't have assets. So then it just begs to wonder who owns the business office that's right next to the circulator. Who actually owns that? What is the agreement between, maybe that whoever owns that is leasing it? So that, because that business office, that house could actually be owned by Nakia or her husband, and they could be leasing that to the business.
That's true. That's true. They can do that. That is definitely true.
Which means your business doesn't have assets. And that's one thing that I've seen a lot of businesses do. That's actually the purpose of a holding company.
Mm-hmm.
Right? It's not just to hold other businesses, but you may put, when you have your real estate, your cars, any other assets that you have, you may have them held in one particular business entity. Right. And it's possible to be doing business in another business entity. And so if this business that's actually doing the business gets sued, they can't seize those assets because they're held by the holding company, another company.
That's right. I think that's more of your lane.
Yeah.
Because that's what you do, as far as I know. You do some estate planning as well.
I do estate
businesses.
Mm-hmm. Yeah. But this is interesting because they only have $50,000 in assets, ladies and gentlemen. That who owns, I feel like the brand alone is worth more than $50,000. So who owns the brand? Right.
I think their intellectual property is definitely, it definitely can be said to be worth more than, $50,000. That may be a contingency as far as the bankruptcy. I'm sure that if we're feeling like this, I'm sure some of the creditors may feel the same way.
Yes.
And they dispute that.
Okay. And so they can dispute what they list as their assets.
Most definitely. They can dispute that. There's also going to be a meeting of creditors where they're going to be asked these questions, just like me and you are wondering. I'm sure creditors will be asking as far as who owns what, how are different assets titled. Mm-hmm. Those things will be discussed on a meeting of creditors. And that's where the trustee and the creditors and the debtor, they meet and they talk about these things. And at that point, the creditors pretty much get to ask the debtors whatever it is they'd like to know as far as the business, so they can really dive deep into these schedules and get more information.
So here's another question the attorney in me wants to know, because there's the part of litigation right in the very beginning where we have this fact finding part, which we call the discovery process, where you're able to serve discovery on the other parties. Do you have discovery processes happening in bankruptcy court? Do they still run similar to like general litigation?
Not per se with the Chapter 11. Now, if someone files an adversary proceeding, then that starts all of the regular litigation process that you and I both know and learned from law school. However, in the meeting of creditors, it's not it does not have the rules of evidence. Let's say if you are doing discovery, and it's pretty liberal about asking whatever you like to ask about, as long as it's relevant to the business and their operations and expenses, things like that. Then it's pretty much a liberal type of fact-seeking forum where you can ask these type of questions.
So then they just ask them, and they have to just rely on their answers. I mean, in a sense, that's what discovery is, but you know.
So what happens is that they may ask. So for instance, from this date to this date, what were your revenues? What type of expenses did you have? Things like that. And so the business would definitely have to supply bank records, things like that. And so with these bank records, also with their bookkeeping records and things like that, then the other party is able to pretty much go down and look towards what is actually being done versus what they said they're doing or what they listed on their schedules.
Mm-hmm. Got it. Okay. Wow. That was all very interesting. It was interesting to me. I sure hope it was interesting to you. Is there anything else that you want to leave us with before we get out of here?
Only that Chapter 11 is a very inexpensive, streamlined way to file bankruptcy as a business. The in regards to the classic Chapter 11, that the filing fee on that is very expensive. So they have really
expensive. How much?
So as far as a Chapter 11 bankruptcy, you're looking at a filing fee of around about $1,000, a little bit upwards of $1,000. Whereas in a classic Chapter 11, it's triple that. So even with just saying that,
Oh,
with just the filing fee. So with that being said, it's a very streamlined way to do a reorganization of the debts.
Now, that just don't seem right to me, because if you're going into bankruptcy because you don't have any money, those are some of the most highest filing fees that I've heard of. There's no other, I mean, filing fees are usually $200, $300, $400. I've seen $500 in California.
Right. Yeah.
But that seems to be, which I thought was high at the time, filing a lawsuit in California, $500, but that's a lot of money. So you're telling me it can get upwards of $3,000?
Yes. So, but you have to think about it in terms of debt. So, like, let's just say the Turkey Leg Hut, they owe $5 million in debt. So, for instance, I've seen cases where, let's say, there is a truck where a person owns about, and let's say it's a dump truck, something like that. Let's say the person they owe about $40,000 on the truck. Let's say the truck is not operable, and the truck is only about $20,000 for the parts, but they owe $40,000. So in the bankruptcy setting, it's going to allow them to go ahead and reduce that debt, the amount of that loan. We can reduce it from $40,000 down to the actual value of the asset.
That's a benefit.
That's a benefit. Yes. Also, and sometimes depending on the taxes, if it's not a priority tax debt and it's non-priority, we can get that reduced as well. So a lot of these, and that's why I said initially, they're going to be allowed to, the debtors will be allowed to reduce the amount of debt significantly, and the creditors, a lot of times, especially if they're unsecured, will just have to take whatever they can get. And so that's the benefit of it. So if you look at it at a standpoint of you owe $5 million right now, but you go to bankruptcy court, you could get this all reduced down to $2 million. Hey, that's worth $1,000 in filing fees all day long.
Now here's a question.
Go
With
ahead.
with practicing estate planning, and which trickles into probate law, right? The
Mhm.
courts that handle the wills and transfer the assets from one generation to the other generation. Sometimes there are mortgages that get passed on that are behind, and so I'm curious to know: can an estate file for bankruptcy, or do you have to be a living person or a business?
Okay, so their heirs can file for bankruptcy.
They
Yes.
can. The
Mhm.
estate of because the estate.
Right.
The
So if they're heirs that have an interest in the home, then they can file for bankruptcy. Let's say that it's a home that hasn't paid a mortgage, let's say in a year. So let's say they're $100,000 in arrears.
Mhm.
Then they could file bankruptcy and pay those arrears within let's say they might pay about, because basically you want to spread them out over a 5-year term. So let's say they're just paying maybe $500 a month to go toward their arrears. But of course they're making their regular payments too, but the additional 500 will be going toward their arrears. And within 60 months, then we do the plan so that we can calculate them so that around 60 months they're paid off.
Hmm. So the heirs, now, do the heirs have to be named as executors of the estate? Does it have to be the estate, or before they can actually file for bankruptcy, or can the heirs? How does that work?
So
After this,
okay, so yeah, the heirs would definitely have to show they have an interest in the property. They
okay,
would have to show they have an interest in the property,
meaning
and it's
like a will
meaning a will,
or
affidavit of heirship.
affidavit of heirship.
They
Okay.
would have to show they have an interest. As long as they have an interest in the property, then they could file bankruptcy to keep the creditors from collections or collecting on the debts.
Even if the property hasn't technically been transferred over to the heirs yet.
As long as they can show an interest, because I'm assuming what we're trying to do is to keep the bank from getting the property before we're trying to keep the bank from foreclosing before all of the paperwork gets done, right?
Yeah.
So as long as they can show an interest, then
Okay.
it can be filed.
Okay. And who do the heirs have to file it collectively?
As long as one heir files, one heir would have to file. That would that would be all that's needed. Now in the paperwork, we would list out who all the heirs, are, or the co-debtors or heirs or whatever, but only one person must file it. Now, it's crazy, and I hope this is not confusing, but there are times when a spouse, husband and wife, who live at the same address file for Chapter 13 bankruptcy, and both of them may try to put the mortgages on their bankruptcies. It happens. Yes.
So both of them filing for bankruptcy separately?
Yes. For Chapter 13, it happens.
And they both want to assume the mortgage?
That has happened. Yes.
But only one can assume it.
Right. And so what happens?
The bank is trying to double dip. You don't want to do that.
Oh, no. We're not going to let them double
right?
dip. So, yes. So that's when we have to really, that's when we have to communicate with the bank, and we have to decide who is going to take on the mortgage within their bankruptcy payments.
Okay. Well, I mean, that's that. Now that sounds like love to me, because unlove says you take the mortgage. No, you take the mortgage. No, you take the mortgage. So,
Hey, everybody's acting like it's a hot potato.
right. So they fighting to assume the debt. That's some love in that house.
Right. And so in some of these situations, so sometimes I know the last situation I had like this, the wife filed first. So she was paying the mortgage. The husband filed about 5 months later. And so he agreed to take on the mortgage. So we just let the mortgage company know, hey, he's going to take on the mortgage. He's going to pay that. And she'll pay the other bills that she was paying within her Chapter 13 bankruptcy. I know, right?
Yeah,
Good husband. I was like, good husband.
When you do that, hearts come out in the AI. It don't work on StreamYard. Okay. Well, I mean, this interview was very insightful for me. I thank you for coming here, and I may have some questions. I may need to consult with you on a case that I'm working on.
Okay, let's talk about it. Most definitely.
So let's hop on a quick call when we get off here.
Okay.
And we'll talk more about that. Marye Dean Esquire here at the wallstreetlawyer.com. I have brought to you the talented, intelligent Lashundra Davis Culpepper. Okay.
Thank you so much. Thank you so much. I'm so grateful for the opportunity.
Okay, and we'll get you back in here some more because we're gonna follow this bankruptcy with the turkey leg hut. It's very interesting to me, and it helps you out there learn what to do and what not to do in your own business. I know that you got a question when we were on the panel yesterday, and someone was asking about why do all these billionaires keep filing for bankruptcy and starting new businesses, and what is that about? And you said, what, it doesn't affect your business, it doesn't affect your personal credit.
Right. And it only affects the entity that files. So if you got 6 different, businesses out here, which a lot of people have a lot of different businesses, they have different ideas, they're innovators. You file bankruptcy on one particular business, it does not affect the other 4 or 5 that you may have. For instance, let me give you a quick example. Had a client who purchased a business. It was to sell some type of ammo, some type of new ammo that came out. Anyway, purchased the business. Within 1 year, the government made a ban on the ammo. Ammo is no longer profitable. He cannot sell it. It's a ban on it. So it made sense for him to file bankruptcy on that particular business. But he had other businesses that are still alive, kicking, doing well. So sometimes you have to just get rid of the debt that's drowning you and just, weighing you down.
All right. Well, you heard it here first. We're bringing you this insight for Black businesses because Black wealth is critical to Black power. I'm so happy to have been fortunate enough to interview you this morning, and we will bring you back as more developments happen in the turkey-led bankruptcy. And Marye Dean Esquire here at the wallstreetlawyer.com. If you're looking to schedule a consultation with me or with attorney Lashundra Davis Culpepper, you can see the links in the chat. Make sure you hit the share and subscribe button because this information was very valuable. If it was valuable to you, it might be valuable to someone else. And remember, Black wealth is critical to Black power. So make sure you join the Black Wall Street Revolution. And I dropped the link in the chat below. Have a great day and bye.
Thank you so much.
Okay.